the second round of oral argument of the Gambia. I now give the floor to Ms. Tafadzwa Pasipanodya. You have the floor, madam.
Good afternoon, Mr. President, distinguished members of the court. Myanmar's core submissions in response to the discriminatory laws and policies targeting the Rohingya are that they are immaterial to genocidal intent, that the 1982 citizenship law is not materially different from the 1948 framework, that restrictions on marriage, birth, and legal identity were limited and non-suppressive, and that segregation, confinement, and movement limitations cannot evidence genocidal intent. The record, including witness NJ's testimony, shows otherwise. The court heard witness NJ explain that although born in Rakhine State to parents, grandparents, and great-grandparents who lived in Burma, she had no citizenship, no birth certificates for her children, and was pressured to accept a national verification card branding her a foreigner. When she refused, authorities denied her schooling, movement beyond her village. Authorities compelled her and her husband to pay a bribe to be able to marry and made them pledge not to have more than 2 children. In August 2017, soldiers came to her house, beat and killed her husband and father-in-law, stabbed and killed her 2-year-old son, gang raped her and burned her home and village. She fled to Bangladesh and has never returned. The acts suffered by witness NJ are the foreseeable result of a state system designed and enforced to destroy the Rohingya in whole or in part. Under this court's jurisprudence, intent may be inferred when the cumulative pattern admits no other reasonable explanation. Moreover, tribunals have held that prohibiting marriages and preventing births are genocidal measures, and that deliberately imposed living conditions that, quote, ultimately seek the death of the group, deprivation of food, medical care, shelter, and movement, also constitute genocidal acts under Article 2C and 2D of the Convention. And history confirms the relevance of genocidal discriminatory laws and policies, from Nazi legal denationalization and segregation to Rwanda's identity card regimes. Such laws and policies were found to be paradigmatic measures that paved the way to physical destruction. Mr. President, Myanmar's council conceded that the Rohingya constitute a group protected by the Convention. The Rohingya have a long and documented history in Rakhine State. Moreover, Myanmar's council did not dispute that in the decades following independence, the Rohingya belonged to Myanmar's polity, that the highest government officials publicly recognized the Rohingya by name and as, quote, one of the ethnic races of Burma, that Rohingya served in public office, and that the Rohingya language was used in public broadcasting. This matters because what followed was a deliberate re-engineering of the polity to exclude and erase the Rohingya. Myanmar's council contests this by asserting that the 1982 citizenship law is not materially different from the 1948 one because the latter also referred to certain ethnic groups. But the laws themselves show a decisive legal pivot. The 1948 Act referred to indigenous races only to define the term's use in the Constitution, expressly extending the concept to any other racial group that had settled in Burma before 1823. More importantly, the 1948 framework established broad race-neutral routes to citizenship for, quote, any person whose ancestors for 2 generations made the Union their permanent home and whose parents and self were born there. By contrast, the 1982 law fundamentally reoriented citizenship around, quote, national races and a strict jus sanguinis regime, designating members of national races as citizens by birth and relegating others to downgraded associate and naturalized categories, and authorizing the state to determine which ethnic groups are, quote, national. Myanmar has not disputed that the national races defined in the 1982 law were later subdivided by military instruction into 135 groups from which the Rohingya were excluded. Counsel for Myanmar's suggestion that the associate and naturalized citizenships are not inferior is incorrect. The 1982 law subjects these categories to rights which may be curtailed, quote, from time to time, imposes onerous discretionary entry criteria, and does not provide for the automatic transmission of citizenship by birth to their holders' children, among other differences. These provisions, combined with the 1982 law's authorizations that authorities need not, quote, give any reasons in matters carried out under this law, enabled systematic exclusion. The resulting statelessness of the Rohingya, which Myanmar does not dispute to be on an unprecedented scale, is the predictable effect of the 1982's law and structure and implementation. Nor has Counsel for Myanmar denied that hundreds of thousands of Rohingya were forced to flee to Bangladesh following an operation for, quote, scrutiny of illegal immigrants in 1991 and 1992. Myanmar's counsel simply dismisses reports by UN institutions and NGOs of military violence without providing any evidence, and invokes later repatriations as inconsistent with genocidal intent. But repatriation under international pressure does not negate intent. It sits alongside evidence that the state repeatedly deployed force to destroy the Rohingya of northern Rakhine State and repeatedly re-engineered law and documentation to deprive and erase those who remained. Myanmar's counsel also argues that NVCs are a neutral step in verification.
Counsel, could you slow down a little bit? The interpreters are having a problem.
Thank you, Mr. President. Myanmar's counsel also argues that NVCs are a neutral step in verification, and that difficulties claimed by Rohingya are speculative or self-inflicted through refusal to apply. But Myanmar's counsel accepts that NVCs do not evidence citizenship and, in fact, confirm foreign status, that applicants cannot record Rohingya identity and must accept the label Bengali, and that those without NVCs face movement barriers. The UN fact-finding mission explains that on the ground, the citizenship process for those belonging to the national races was expedited, while the Rohingya were shunted into a protracted and coercive track. One of the state pamphlets circulated to the Rohingya is on the screen. If you want to do fishing, apply for the NV card first. For social and economic activities, hold the NV card. To have guarantee of life, keep NV card together with you. To have guarantee of life, keep the NV card together with you. As witness NJ explained, she refused to accept an NVC that branded her a foreigner in her country of birth. I quote, "That card says we are not nationals of this country. That's why we didn't accept it." Witness NJ also explained the deprivation and risk that resulted from the decision not to take the NVC. I quote, "We were not allowed to go outside, anywhere else within our township. If we went, if it was found out, then we were beaten, we were tortured." Contrary to Counsel for Myanmar's assertion that Rohingya could attend school without an NVC, she testified, I quote again, "Myanmar military didn't allow us to attend any school." The insistence on erasing a group's very name while conditioning survival on accepting foreign identity is an indicator of genocidal intent recognized by the UN fact-finding mission. I turn now to the suppression of family life and births. Counsel for Myanmar concedes that Regional Order 1/2005, adopted for the express purpose of, quote, controlling the Bengali population for the good of the region and the race, was in force between 2005 and 2018. He says, however, that the regional order was neutral, did not state a specific limit on the number of children, and that there is no evidence a two-child limit was ever strictly enforced or effective. Members of the court, witness NJ's experience is the lived imprint of that regional order. In response to questions from the court, she explained that she was forced to pay a bribe to get married, sign a paper not to have more than 2 children, and even had to hide one of her twin children from inspections or risk fines and imprisonment. Myanmar's council's denial of the existence of a 2-child limit for the Rohingya is also belied by Myanmar's own spokesperson, who acknowledged the limit in 2013. Myanmar's council also asserts that there is no evidence of weight that these orders suppressed births or led to abortions. Its efforts to discount the UN fact-finding mission's reports and an extensive reproductive survey across 9 village tracts conducted by Médecins Sans Frontières while offering no independent evidence of its own is unpersuasive. Myanmar's council did confirm, however, that Myanmar generally failed to provide Rohingya newborns with birth certificates from 2012 to at least 2017, and only intermittently since, although the Gambia's position is that this practice dates back to the 1990s. Myanmar's council's attempt to justify this failure, invoking riots over a decade ago, the COVID pandemic, or the Rohingya's alleged lack of awareness about registering births, is not convincing. There is no evidence that the provision of birth certificates to newborns of any other ethnic group who would be equally impacted by those factors has been similarly affected. Witness NJ explained that in her experience, the Rohingya are never given the opportunity to obtain birth certificates for their children. Consequently, there is no official record that her 2-year-old son, whom the military threw into a burning house, was ever born, let alone that the military killed him. The same can be said of the children of Witness MS and the multitude of other Rohingya children who were killed in the clearance operations, but whose birth has never been recorded by Myanmar. The UN mission summarizes the consequences. Denial of birth certificates, quote, deprives Rohingya children of a permanent record of existence and legal identity, and negatively impacts their access to health, education, and other services. Taken together, these measures are calculated to suppress Rohingya family formation and births and to erase legal personhood, precisely the sort of conduct tribunals recognize as probative of genocidal intent. They are genocidal. The discriminatory laws and policies targeting the Rohingya culminated in the clearance operations and have continued since. Myanmar's council did not refute that following the clearance operations, Myanmar pursued demographic replacement in Rohingya areas, establishing Buddhist model villages on Rohingya land, announcing that the Rohingya would not return to their original villages, and encouraging, facilitating with documentation, and sponsoring with living stipends the settlements of Buddhists from Bangladesh into Rohingya majority areas. In conclusion, Council for Myanmar indicated that not all discriminatory acts are genocidal, but that's not the issue. The court must determine whether genocidal intent is the only reasonable inference from the acts considered together. The discriminatory acts and architecture I have described reflect a genocidal intent and contributed to the genocidal acts that followed. Mr. President, members of the court, thank you for your kind attention. May I respectfully invite you to call Mr. Suleiman to the podium.
I thank Ms. Pasipanodya for her statement.